Improve upon the statements and the arguments that have been made by my good friend from Arizona. I come from a little different perspective, and there are a few things that perhaps, in my opinion, I have 6 things, I think any one of which would seriously make us consider voting against her. I want to say this first of all, though, that back when she was first nominated, I was the first one to say I was opposed to her, and the main reason was these things came up, most of them, when she was up to be confirmed for Solicitor General. And at that time, I objected to her in that position. And I have a policy I think is good, and people in my state of Oklahoma know it, and that is, if you oppose someone's nomination, confirmation, for a position, then they come back later for a higher position, it's automatic because the bar should be higher. Well, anyway, today, I want to just reemphasize a couple of things that were mentioned by my friend from Arizona. One objection to Kagan's nomination is that she undeniably lacks the experience. I think that Senator Kyle said it very well. People would say, well, there have been some others in history that didn't have any judicial experience on the bench. But in those cases, they averaged 21 years of practicing before the justices. I mean, so they've had that experience. This will be the first time in history we have someone with less than 2 years experience and no judicial experience that will be, so that would be a reason enough. That isn't my major objection. My major objection is her disdain for the United States military. While dean at Harvard, Kagan banned the military during a time of war from recruiting on campuses due to her objections over the don't ask, don't tell policy. That was the policy that was put together, I have to add, during the Clinton administration. While she was in the Clinton administration, she did not object to it at that time, but she objects to it now. And there have been much made about her supporters about the role of this in this incident, but the truth is that in November of 2004, after the Third Circuit Court of Appeals struck down the Solomon Amendment, now I was there when the Solomon Amendment was passed in the House, and they struck it down. Kagan affirmatively disallowed the military from recruiting at the school's Office of Career Services. Subsequently, Kagan joined 40 other schools in filing an amicus brief with the Supreme Court in the case opposing the Solomon Amendment, which was then overwhelmingly opposed and reversed by the United States Supreme Court unanimously. And so she was taking advantage of that opportunity where she felt that she didn't have to allow recruiters at the universities. We've seen this happen around the country, not just Harvard, but out in California. And this is something that is definitely in opposition to the law that is still in place that was referred to as the Solomon Amendment. Now, equally alarming to these actions is her misrepresentation of the facts before the Judiciary Committee. I wasn't aware of this, certainly not back when she was up for Solicitor General, but she testified that military recruiters had full and good access to Harvard's campus. Military recruiters clearly did not have full and good access, as they had to work through the school's veterans group as opposed to being allowed to go through the Office of Career Services, a part of the university. Internal Pentagon documents reveal that under Kagan's deanship, quote, this is a quote, the Army was stonewalled at Harvard. Furthermore, Kagan told the committee that in banning recruiters, she, quote, always thought we were acting in compliance, unquote, with federal law. Yet in her own email to Harvard students and faculty, she wrote that she had hoped that the government, quote, would choose not to enforce the law. I'm alarmed that Kagan would not allow, not only ban military recruiters on campus in the time of war, but that she would do it to advance her own liberal and social agenda. And then mislead the Senate committee and the judiciary with their statements. Also, during her tenure as dean of Harvard, Kagan sent a letter with 3 other law school deans to the Senate in 2005 opposing legislation that sought to prevent terrorists convicted in military tribunals from appealing their convictions in federal courts. She compared this legislation to the fundamentally lawless actions of a dictatorship that have passed laws stripping their courts of power to review executive detention or punishment of prisoners. That's all a quote. It's not what I said. That's what Ms. Kagan said. And they we have the best judicial system in the world, and equating our laws relating to the war on terror is that of a dictator. To a dictator would be laughable were it not so pervasive in liberal academia. Kagan has a history of misrepresenting facts to push her liberal agenda, including her effort while working in the Clinton administration to change the statements of 2 medical associations to withhold the truth about partial birth abortion. Now, this is interesting because we're going to talk about 2 medical groups here. Both had a very firm position, and she influenced a change in that position. During the debate over the Partial Birth Abortion Ban Act, Kagan wrote a memo to President Clinton in December 1996 objecting to the release of the American College of Obstetricians and Gynecologists, called ACOG, proposed statement that partial birth abortion is never medically necessary. Now, this is what their position was. They came out and said, these are the gynecologists and the obstetricians. They came out and said that it was never necessary. The release of the statement would, of course, be a disaster. Those are her words talking to at that time, the Clinton administration. Now, we have evidence from Kagan's handwritten notes that she advocated a change in the statement to reflect that partial birth abortion may be medically necessary. 1 month later, the obstetricians and the gynecologists, the statement by their group, ACOG, released their statement with language nearly identical to Kagan's language that such abortions may be medically necessary to save the life and preserve the health of the mother, of the woman. In addition to seeking to change ACOG's position, Kagan also sought to alter the American Medical Association's position on partial birth abortions. She once again tried to alter their facts and encourage the AMA to change its medical policy on partial birth abortion. What is perhaps more concerning about Kagan's efforts to manipulate the medical policy of ACOG and AMA is that these medical policy statements were then used, sometimes successfully, in the federal courts to invalidate state laws and partial birth abortion ban acts. She manipulated medical facts to advance a barbaric practice and push a political agenda. What we're talking about here, 2 of the highly respected medical associations who said that partial birth abortion was not in any way something that was necessary, to change their position, and then that was later used in court cases. Moreover, Kagan criticized the Supreme Court decision of Russ versus Sullivan, which upheld the Department of Health and Human Services regulations prohibiting Title X family planning funds from being directed towards, quote, programs where abortion is a method of family planning. Additionally, while clerking for Justice Marshall, she authored a memo arguing that, quote, all religious organizations should be off limits from receiving federal funds for programs authorized by the Adolescent Family Life Act, such as pregnancy testing, prenatal, postnatal care, adoption counseling, and child care, because these programs are, quote, so close to the central concerns of religion, unquote. You know, I seriously question Kagan's willingness to honor and defend the Second Amendment, getting into that area that is probably more sensitive to a lot of the people, my friends, including my son and members of the family who are very active and very strong believers in Second Amendment rights. While clerking for Justice Marshall, Kagan wrote a memo about a case challenging Washington, D.C.'s strict gun control laws. In only 4 sentences, she was dismissive of the case, writing that she was, quote, not sympathetic, unquote, to an individual rights view of the Second Amendment. She was not sensitive to an individual rights view of the Second Amendment. As everyone knows, the Supreme Court has since upheld the individual right to keep and bear arms. Kagan also used her position with the Clinton administration to advocate various anti-Second Amendment initiatives. Documents from the Clinton Library illustrate that she supported background checks for secondary market gun purchases as well as municipal liability suits against gun manufacturers. She helped develop an executive order banning the importation of certain types of semi-automatic weapons that were not covered by the 1994 assault weapons ban. She also sought to permit law enforcement to retain Brady background checks information on lawful gun sales. Finally, in an internal document regarding the Volunteers Protection Act, she described the NRA as a bad guy organization. Well, you know, she might get by with that in this chamber, but she wouldn't get by with it in my state of Oklahoma. We read the Constitution. We know what it says. She has no respect for the Second Amendment. I'm also gravely concerned, based on Kagan's writings and statements, that she would be a judicial activist who would seek to legislate from the bench. In her 1998 master's thesis at Oxford, she wrote, and I'm quoting now, "As participants in American life, judges will have opinions, prejudices, values. Perhaps more important, judges will have goals. And because this is so, judges will often try to mold and steer the law in order to promote certain ethical values and achieve social ends. Such activity is not necessarily wrong or invalid." She's stating from a very, not just today, going all the way back to her Oxford days, that judicial activism is very appropriate. Rather than affirm the role of judges as the faithful interpreters of the law, Kagan voiced her support for judges that seek to serve as legislators who develop their own empathy standards and apply the law in a manner they personally see fit. Her self-acknowledged judicial hero, Aaron Barak, perfectly fits this mold. In her testimony before the Judiciary Committee, she even affirmed that she would consider foreign law when she decides cases. She said, "I guess I'm in favor of good ideas from wherever they come." What we're talking about is referring to other countries who have a different judiciary system and saying, maybe they're right and maybe we're wrong. I simply cannot support a nominee who looks to other judicial systems or judicial philosophies or evolving standards of decency rather than the text of the United States Constitution to interpret law. So I've thoroughly reviewed the record of Elena Kagan and have come to the firm conclusion that she lacks the qualifications and experience to be the Supreme Court Justice. You know, I've named 6 things here. Any one of these 6 things, in my mind, should be disqualifiers. And this is just one thing. This is 6 things. One is she wants to consider foreign judiciaries. Another is she has no experience in judicial or in trial experience. Third, she is the judicial activist. 4, she's very extreme in her philosophy on abortion, Second Amendment, and she's anti-military. You know, I think of all these things that I've mentioned, probably the part that concerns me most is when her position, that if we are trying someone in a military trial, maybe a terrorist, an activist, and they come to some conclusion that they would give that terrorist the right to appeal that to our court system and inherit all the benefits that any citizen in the United States has. So I'm very, very much concerned about this, and I can only say that the statement that I made several months ago now when she was first nominated, that if she, in my opinion, as one of 100 senators, is not qualified to be Solicitor General, she's certainly not qualified for a higher job, Justice to the United States Supreme Court. And Mr. President, I know I'm out of time here, but I want to mention that I was hoping to get down today and talk a little bit about one of the problems that's going to come up tomorrow, and that is of the Democrats and the Republicans' energy bills. I'm concerned very much about the process that has been very successful to extract oil and primarily gas out of tight formations called hydraulic fracturing. Hydraulic fracturing started in my state of Oklahoma in 1949, over 60 years ago. And we've used hydraulic fracturing to get at these tight formations. For 60 years, there has never been one case of any kind of contamination of water. And I think that there are people who just want to do away with our ability to run this machine called America. They don't want oil, they don't want gas, they don't want coal, they don't want nuclear. And that kind of gives you an idea of what might be behind this. Now, some say, well, no, we're not against hydraulic fracturing. This bill merely says that we want the federal government to know what chemicals are used. This is already being done on a state-by-state basis. Things aren't the same in Oklahoma as they are in New York. In Oklahoma, we have very strict rules. They know exactly what chemicals are used. And by the way, 99% of what is used to force these formations is water and sand. And again, never has there been a case. I also am looking forward to talking in some more detail because Senator Casey is a good friend of mine. He is kind of the author of this portion of the bill, and yet his state of Pennsylvania has huge opportunities for natural gas, and I think we need to talk about that. You know, we have enough natural gas that if we would take away all the inhibitions we have and keep hydraulic fracturing as a process that can be used, we have enough natural gas to run this country for 100 years. So I think it's our job to make sure that we protect that, and with that, I would suggest absence of quorum.
Would the